Good day, Crime Talk aficionados. We have a great show for you today. It's going to be a big one. First, we got an update on Luigi Mangione. We have a Mangione copycat got arrested. Crystal Mangum finally admits she lied. Morgan Wallen going to do 7 days in jail. This guy, I like his style. Kill your dad, get an attorney, and then take the body to the police station. Sarah Boone, she just can't shut her mouth. An unfair fight or a leveling of the playing field, perhaps. Alec Murdaugh continues with his appeal. We have this day in legal history and our dumb criminal of the day. Let's talk about it.
Hi, lawyer.
Good day, everyone. Thanks for joining us. My name is Scott Reich, and this is Crime Talk. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that little bell for notifications. And yes, you can check us out anytime on any of your favorite podcasting apps. Hey, I'm urging you, go to crimetalksearch.com. Sign up for that background subscription service today. When you do, you're going to be able to do as many background searches as you desire on anyone here in the United States, and you're going to be able to get information as to whether this person has, I don't know, a bunch of burner phones, their social media presence, emails that they use associated with their social media presence. You're going to get a criminal history background. Do they have a lead foot, or do they have, sex assault convictions? Things you want to know. Go to crimetalksearch.com and find out. You're going to be happy you did. Hell, it could even save your life. All right, let's go ahead and open the record for Friday, December 13th, 2024. First, Luigi Mangione. Detectives investigating the assassin Luigi Mangione say there is no indication that he actually was ever insured by United Healthcare, despite allegedly shooting their CEO last week. So the chief of detectives, a guy by the name of Joseph Kenny, said that Mangione may have targeted CEO Brian Thompson on December 4th outside that Manhattan Hilton hotel due to his status as the America's largest health care insurer. Well, it's also emerged that the San Francisco Police Department officers recognized Mangione and contacted the FBI 4 days before his arrest. Now, police sources are stating that an officer in the San Francisco Police Department Special Victims Unit made the connection on December 5th, the day after the NYPD released surveillance images of the suspect of the assassination. Anyway, despite allegedly reporting the connection the same day when Mangione was arrested on November 9th, the New York police insisted that that was not on their radar at all. Anyway, Mangione's arrest obviously has captured a lot of headlines and attention and sent social media into a frenzy, with many questioning how an Ivy League educated, handsome computer programmer from a wealthy family became an alleged assassin. I guess we're going to find out. Anyway, a grand jury has been convened in New York following Mangione's arrest, although he is going to fight extradition, which will take a little bit longer. But mark my words, ladies and gentlemen, he will be in New York sooner than he can say, ouch, my back hurts. Anyway, his next court date in Pennsylvania is December 23rd. So after the NYPD was criticized as the suspect seemingly slipped out of the city before he was apprehended through luck some 300 miles away, the detective said that they have zeroed in on Mangione's movements after the shooting. Now, the detective said that Mangione's family reported him missing in San Francisco in November, and he arrived in New York City's Port Authority bus terminal on November 24th. The detective said that Mangione then immediately goes to the McDonald's in the vicinity of the Hilton Hotel before making his way to the hostel in the Upper West Side. Now, the detective said Mangione was coming and going on a regular basis from the hostel over the next few days, often using e-bikes throughout the city. And then immediately after allegedly shooting Thompson, he got a cab to North Manhattan to the George Washington Port Authority bus terminal as well. Now, the NYPD are still uncertain how Mangione got to Pittsburgh and then to ultimately his arrest in Altoona, Pennsylvania. And he was apparently getting money from an ATM machine. Everything he did was paying for in cash. Now, Mangione was allegedly found with $8,000 in U.S. currency and some $2,000 in some unspecified foreign currency as well. Now, he did deny that when he was arrested, and saying at his initial appearance that that must have been planted. Now, other evidence brought against Mangione include a water bottle and a Kind Bar wrapper found at the scene of Thompson's murder. that he allegedly bought from the Starbucks half an hour before the shooting. Now, the gun found in Mangione's bag when he was arrested also matches the shell casing found at the scene. Mangione is apparently quite influential because, well, people are copycatting what he has to say. But a Florida woman has found out that, that could be a true threat, ladies and gentlemen. So a Lakeland, Florida woman has been charged after police said she ended a call to an insurance company with the words delay, deny, and depose. Now, in the arrest affidavit, the Lakeland Police Department said that officers were contacted by the FBI on December 10th regarding the alleged threat made over the phone. So Brianna Boston has reportedly placed a call to Blue Cross Blue Shield regarding recent medical insurance claims were denied. The entire phone call was recorded, according to the arrest affidavit. And near the end of the call, investigators say that Miss Boston could be heard stating, delay, deny, depose. You people are next. The first three words are similar to those written on the ammunition that a gunman used in the killing, obviously, of the United Healthcare CEO Brian Thompson in New York. That's right, Mr. Mangione. Anyway, the affidavit noted that the similarities between the incident, stating that those words have become nationally recognized as a phrase directed against insurance companies, is bad. Anyway, she has been in the world long enough that she certainly should know better, that you can't make threats like that in the current environment that we live in and think that we're not going to follow up on those threats, said the Lakeland Police Chief Sam Taylor. Now, police made contact with Ms. Boston at her home in Lakeland, Florida, where she reportedly admitted to using those words during the call, telling detectives that the healthcare companies played games and deserved karma from the world because they are evil. Now, Ms. Boston reportedly told detectives she used the phrase because it's what's in the news right now, and that she had learned the phrase due to the United Healthcare homicide. However, Ms. Boston added that she does not own any firearms and was not a danger to anybody. Now, she readily admitted that, yeah, that's exactly what I said, but I didn't mean anything by it. Well, that Chief Taylor guy once again says, well, you don't get to pull that back after you say it. So based upon Ms. Boston's statements, investigators said they believe that she meant a threat to the insurance company, and therefore she was arrested. Now, Boston has been charged with threats to conduct a mass shooting or an act of terrorism, according to the arrest affidavit. Now, when arguing bond, Ms. Boston's attorney noted that she is 42 years old, married, mother of 3, doesn't have a single charge or conviction on her criminal history record, and requested a personal recognizance bond, which attorneys often do. The judge said denied, set her bond at $100,000 and said, quote, I do find that the bond of $100,000 is appropriate considering the status of our country at this point. Boom. There you go, ladies and gentlemen. We've talked about true threats. I've done lots of true threat cases over the years. And even if it's factually impossible that you could go do something like that, well, guess what? You still shouldn't say it. Discretion is the better part of valor, ladies and gentlemen. I get it. It was said in the heat of the moment. She's frustrated and, saying, deny, depose, and delay, obviously, her argument is going to be this is protected by free speech. That is going to be the defense. For a true threat, through United States Supreme Court case law, has basically said that it is a subjective intent. The prosecutors have to prove that the person making the statement, that it was their intent to put the other person in fear at that time, because for many, many years, it was simply, what did the person feel? Oh, I was scared and intimidated. So, like I said, the Supreme Court looked at it and said, no, you have to prove what the person's intent was. The defendant's intent was that her intent to put that healthcare worker in fear of, some sort of death or serious bodily injury, and that she would have reasonably believed that that would have been enough to do it. Close call for sure. A lot of people may be sympathetic. Who knows? $100,000 bond, assuming she makes that. Get out, fight that case, I would say. Let a jury decide if it was truly a true threat or not. But be careful, ladies and gentlemen. Take it from your local criminal defense attorney. Err on the side of just be nice. I get it's frustrating, but don't threaten people. Just Keep it simple. Now, don't get me wrong. I still believe in the First Amendment. That's probably protected under First Amendment grounds, but it could go either way if a jury believes that that was her subjective intent, what she believed, not the objective intent of, well, a reasonable person would do that. You know how I feel about negligence, and reasonable person in criminal law, ladies and gentlemen, has no place there at all. They have to prove that that's what she intended to do, was to put that person in fear or harm. A reasonable jury could conclude that. Next, that's right, the Duke rape case. Now, this has been a case gone on many, many years ago, ladies and gentlemen, 18, I believe, in fact. And, well, finally the truth comes out. I always tell people the truth, or a pretty darn close version of it, will come out. It just took a little longer in this case. So the woman at the center of the Duke University lacrosse rape case has admitted that she lied when she accused 3 men of sexually assaulting her back in 2006. Now, this woman, Crystal Mangum from Durham, North Carolina, came in the spotlight in 2006 when she was accused, a trio of being gang raped at a party where she was hired to be a stripper at this Duke frat house. So the now 46-year-old mother of 3 is currently in prison after being convicted of second-degree murder and stabbing her boyfriend with a kitchen knife back in 2011. Anyway, it was from prison that she did an interview with a podcast, and anyway, that interview was released on Thursday. And there, Miss Mangum admitted that she made the entire story up. She says, quote, "I testified falsely against them by saying that they raped me when they didn't, and that was wrong. And I betrayed the trust of a lot of other people who believed in me," she said. Now, Miss Mangum even admitted that the 3 men trusted me, that I wouldn't betray their trust. That's right, because she was being paid as a prostitute or a stripper, right? There's a certain code among prostitutes. But apparently not for Miss Mangum. Anyway, she said, "I made up the whole story that wasn't true because I wanted validation from people and not from God." She claimed that it was her search for validation that led her to become a stripper despite having a college education. Now, Miss Mangum then asked the 3 men she accused, David Evans, Colin Finnerty, and Reed Segelman, to accept her apologies. She said, quote, "I want them to know that I love them and that they didn't deserve that, and I hope that they can forgive me," end quote. She went on and said, "I hope that they can heal and trust God and know that God loves them and God is loving them through me, letting them know that they're valuable and they didn't deserve that," end quote. Now, Ms. Mangum made it clear that she didn't attempt to find religion in prison, saying that she mostly reads the Bible to get through the day. She says you can get a lot of growth through Jesus, and apparently Jesus has enough, and we're enough, is what she's realized. Anyway, she claims that she would describe her time in prison as one of growth. However, she did say that she had no regrets and that everything happens because of God. Anyway, the case became one of the most racially charged in recent memory, which ended explosively when the prosecutor was disbarred, and the 3 young men were ultimately declared innocent and got a big payday. Now, the case began back in March 13th of 2006, when 3 of the 4 co-captains of the men's lacrosse team at Duke hosted a party for their teammates at their off-campus house. The group had paid a total of $800 for 2 exotic dancers to perform, one of whom was single mom, Miss Crystal Mangum, who was a student at the North Carolina Central University. All but one of the players on the lacrosse team were white, and in the aftermath, Crystal, who is black, made a series of allegations against 3 of the team members. She accused Evans, Segelman, and Finnerty of raping and sexually assaulting her in the bathroom. And the ensuing fallout created a firestorm across the nation, highlighting racial and socioeconomic divides at the elite university and beyond what is known as the Duke lacrosse case. The coach was forced to resign, and the university canceled the remainder of that season that year. Now, speaking after he was indicted, David said, "You have all been told some fantastic lies, and I look forward to watching them unravel in the weeks to come as they already have in the past week. The truth will come out." Well, the students hired defense attorneys, but the situation became hazy when Crystal claimed she could no longer recall the exact details of what happened that night. Now, the DNA evidence failed to match any of the 46 white players on the team, and she eventually recanted her statements. She later said she was not sure that she was actually raped, but insisted some sort of sexual assault had taken place. Now, the tide eventually turned on the prosecutor, Mike Nifong, who had overzealously championed his case in the media. The boys' defense attorneys pleaded for the North Carolina State Bar to intervene, and charges were brought against the sitting district attorney for the first time in the history of North Carolina there. It was decided that Nifong had been too outspoken and concealed the crucial DNA evidence findings from the investigation. Like I said, he was ultimately disbarred. You can't keep those exculpatory evidence from the defense. That is unethical, and yes, Mr. Nifong should have been disbarred. As a result, the case was then handed over to an alternate district attorney, a guy by the name of Roy Cooper, who dropped the charges against the players just 4 months later. Cooper recently finished up the term as the state's Democrat governor. Now, he declared that the college students to be innocent and branded Nifong as a rogue prosecutor. Ultimately, the case did not go to trial, and the three players each received $20 million each in a settlement with Duke. Duke University paid up because they kind of threw them under the bus, ladies and gentlemen. Anyway, the house where this allegedly took place has since been torn down, and the university spent more than $100 million on legal fees, settlement costs, and other expenses to preserve its brand, all because somebody lied, ladies and gentlemen. Anyway, Crystal, who later released a memoir titled The Last Dance for Grace, the Crystal Magnum story, was never charged with making false accusations, but her legal troubles would only continue to get worse. Just a short time later, back in 2010, she was convicted on a misdemeanor charge of setting a fire that nearly blazed her home with the three children inside. Now, in a videotaped police interrogation, Crystal told officers she had gotten into a confrontation with her boyfriend at the time, Milton Walker, and burned his clothes, smashed his car and windshield, and threatened to stab him. The single-story duplex had heavy smoke damage, but no one was hurt. But there was still one tragic thing to take place. In April of 2011, Miss Magnum and her 46-year-old boyfriend, Reginald Day, who had been dating for about a month, had been caught up in a heated argument after she was allegedly caught flirting with another man. She claimed that Reginald had been beating her at the time before she snatched the kitchen knife and stabbed him in self-defense. Crystal told the court that he straddled me, hit me, and then he started choking me. I couldn't breathe. My head hurt really, really bad. I was just trying to survive, and I felt that Reginald was trying to kill me. Well, the mom ultimately poked him in the side of the chest at the apartment in a call to emergency personnel. After the stabbing, Reginald's nephew told the operator, "It's Crystal Magnum. The Crystal Magnum. I told him she was trouble from the damn beginning." Reginald died 10 days later at a Duke hospital due to complications from his injuries. It took the jury just 6 hours to reach a unanimous verdict of guilty. And Miss Crystal Magnum was then 34, got sentenced to a minimum of 14 years in prison for second-degree murder. Shows you, ladies and gentlemen, don't get me wrong. I mean, terrible things can happen to women. I've seen lots of cases that were absolutely true, I assure you. Where true allegations were made, where they were not false. And I have seen cases where false allegations have been made. And yes, it can turn somebody's world upside down, their reputation in the community, their ability to obtain work, having to spend a fortune on legal fees. All those things matter. And when somebody lies, there should be punishment for people that lie like that. Next on the docket, Morgan Wallen. That's right, the country music star. Well, he was in court yesterday and pled guilty for the April 2024 incident where he threw a chair off a roof of a Nashville bar. That's right, the country music star pled guilty to 2 misdemeanor counts of reckless endangerment in Nashville, Tennessee, on Thursday, 7 months after waiving his first court appearance. The counts were reduced from the Class E felonies that he was charged with when he got arrested. Now, Wallen will be incarcerated for 7 days in a DUI education center before proceeding to be supervised by their probation department for 2 years. He appeared in court and, did what he had to do. During the whole 10-minute court appearance, the judge asked Mr. Wallen how he pled, and he said conditionally guilty. Now, Wallen's attorney appeared alongside the star as he issued a statement after the proceedings, which stated that this will not result in a conviction as long as Mr. Wallen adheres to all of the provisions. So basically, he's getting a deferred judgment and sentence, ladies and gentlemen. Would you have gotten that, or do you think Mr. Wallen and his superstar status may have helped a little bit? We'll have to wait and see. Anyway, apparently it's alleged that Mr. Wallen was completely cooperative with authorities throughout these past 8 months, directly communicating and apologizing to all those involved. And he is committed to making a positive impact through his music and his foundation. Now, in addition to the 2 misdemeanor counts, Mr. Wallen will also have to pay $350 fine and pay court fees. Now, according to the arrest affidavit in this case, the chair landed about 3 feet from officers who were talking to witnesses, and they were reviewing security footage. Now, witnesses told officers that they watched Wallen pick up a chair, throw it over the roof, and then laughed about it. Wallen was arrested and released ultimately on a $15,000 bond. Thank goodness no one was hurt, particularly those officers. Otherwise, Mr. Wallen, he'd probably go into prison for more than 7 days in a county DUI thing. Oh my God, there's going to be like staying at a hostel or something. Jeez. All right, next on the docket. I like this guy's style. He must be watching CrimeTalk. Lawyer, lawyer, lawyer.
You, get up. Yeah, you.
All right, lawyer, lawyer, lawyer.
Anyway, some details have come to light about the man who's a convicted felon charged with murdering his father, whose body he reportedly turned in Monday night to the sheriff's office. So Richard Flugel Jr. of Rochester, New York, is now facing murder and weapons charges and evidence tampering charges for the death of his 60-year-old father, Richard Flugel Sr. Now, Flugel was arraigned and pled not guilty the other day in court. The Livingston County Sheriff, a guy by the name of Thomas Doherty, said Flugel Sr. left his residence Sunday afternoon and never returned. His vehicle was found early Monday in a parking lot in Dansville. Anyway, Doherty said the homicide scene is believed to be on Bonner Road in Osane, where Flugel Jr. was trying to start a marijuana operation through the state. So the sheriff said, you have 2 scenes here. You have the scene, the original scene, pulling in the parking lot, deceased, body in the car. That's a scene, the sheriff said, and we believe that the actual crime scene is on Bonner Road, and that's why the charge for the murder and the weapons charge is in Osane. The tampering is here in Geneseo County. Anyway, Doherty said a search warrant was executed on the Bonner Road property Tuesday afternoon, and according to the felony complaint, Flugel Jr. is accused of shooting the victim twice with a 12-gauge shotgun, causing his father's death. Deputies said a weapon was recovered, and in court papers it's also alleged that he wrapped his father in a tarp and concealed his body inside the 2018 Audi that he was driving around in. Now, Doherty said while Flugel Jr. was in the parking lot of the sheriff's office to turn in his father's body, he was not the one who called the 911 call center. Apparently, we have a suspect in the car with his deceased father, and in a separate car is his defense attorney, who is a guy by the name of Brian D. Carrillas. The sheriff explained. So the call actually was made by the defense attorney to say, we're out here in the parking lot with a deceased body. Now, Doherty said the attorney is not under investigation in any way whatsoever. Now, the attorney stated that he received a phone call from Flugel Jr. late Monday night explaining that he had a body in his car and recognized he needed legal counsel. So apparently he had never met this individual before, but now he is the client. Anyway, Flugel is being held in the Livingston County Jail with no bond. So here is a good teachable moment, ladies and gentlemen. You would think the attorney would say, go get rid of the body, right? No, wrong. Don't do that. That would be unethical. It's like if somebody came to your office and said, hey, I just murdered somebody and here's the gun. You know, the attorney should not take possession of that other than maybe have an investigator do it and say, but we have to turn this in. So it gets tricky ethically, so to speak, but it's not really tricky, right? If the client comes to you and says, I killed somebody and this is where the body's buried, you can never, ever repeat that to anybody unless you have permission from your client. But if the client comes to you and says, hey, I did something wrong and here's the murder weapon, you can't hide the murder weapon. You can't give it back and say, I don't want anything to know about it. You've got to turn it in. But you can't repeat to the police what was told to you by the client. So the attorney did ethically what he should have advised the client to do, which is to surrender himself, keep your mouth shut, and say, here's the body. Now, I just did this case, ladies and gentlemen. I got a not guilty last year. And, when you got 2 eyewitnesses and one is dead and won't be showing up to court, you got a pretty good self-defense case, ladies and gentlemen. How does the prosecution rebut the affirmative defense of self-defense beyond a reasonable doubt, which is the legal standard, to overcome that? Very, very difficult to do so. And in fact, in this particular case, like my case, the client was the one that called the police and said, oh my God, I was defending myself. See? So it's going to be an interesting case. We're going to follow this one for sure. Next, Sarah Boone just can't keep her mouth shut. So Sarah Boone, just days after she was sentenced to life in prison for murdering her boyfriend, leaving him in the suitcase, Sarah Boone sent a lengthy letter to the court offering her forgiveness to everyone involved in the case. So as you may recall, Judge Boone was sentenced by Judge Michael Kranick to life in prison on December 2nd after the jury found her guilty of killing Jorge Torres Jr. by zipping him into a suitcase, beating the suitcase with a bat, and then leaving him to die overnight. Well, guess what? How long the letter was? 28 pages. And it was dated December 6th, and it's now part of the court record because she sent it to the court. Anyway, Ms. Boone says that she's enclosing the complete statement she wrote, which she only partially read at her sentencing. And she put in there, by reserving particular parts of this very true and meaningful statement, I was hoping to have been graced with your forgiveness, understanding, and consideration in any level of degree. For me, unfortunately, and regardless of whom I had to speak with on behalf of this matter made up, I have also added to my statement as a result of your blindness and impartiality, foremost your disgust in me as being an outspoken woman, determined defendant, and proactive client, hoping the next time you put your listening ears and do not unfairly oppress the next as you have so blatantly done me. I'm sure the judge just thought, oh my gosh, I need to reconsider her sentence. I have been oppressing this outspoken defendant. No. Anyway, the letter moves through different players in the case, offering forgiveness and criticism for each. Boone accused the judge of a clear error and full-blown unfair bias before turning her attention to the prosecutors. Quote, I forgive your antics, theatrics, ludicrous comments to make sure the world got their money's worth while watching with ignorant pitchforks and burning torches, hoping for the best of you, which is my worst. Instead of dropping the mic, Mr. J, you dropped the bat. This is not the first time Boone has written a letter to the court. In June, she wrote a 58-page letter expressing her continuing frustration with her attorney. Now, 3 of Boone's former attorneys were all granted forgiveness, but Boone questioned why they were given $15,000 in payment for their work on the case. The letter questioned why she was not included to receive $15,000 share because she worked on that case, and the judge forced her to be her own attorney to be pro se. Now, like I said, Ms. Boone did briefly represent herself after the judge ruled that she had forfeited her right to an attorney through her behavior and unwillingness to get along with anybody that was appointed to represent her. Anyway, judge denied Boone's motion for a new trial after her sentencing, but it is clear that Boone said she excited for her appeal, which she says will speak for itself, and to be free from your corrupt court and free from your malevolent judicial grip. Boone says that she continues to think about Torres and speaks to him while she is alone in the rec yard. I ask his forgiveness and that he look for me at the gates of heaven so that I can tell him how sorry I am endlessly and that I never stopped loving him. Jorge haunts me. He is everywhere she goes. Wow. One of the worst things you can ever get, ladies and gentlemen, is you get a notification that your client or a client's family member has sent a letter to the court. Nothing good is ever going to come from that. Nothing. As you can see from Miss Boone, the trend continues. Nothing good is going to come from that other than everyone thinks she is just a crazy, angry woman and in complete denial of the facts of the case. A jury believed that she was guilty of killing Mr. Torres, and, well, actually, now she's going to spend the rest of her life in prison. But, hey, I get it. She's got nothing to lose at this point. She's going to spend the rest of her life in prison. Get it off your chest, Miss Boone. Next on the docket, an unfair fight or just leveling of the playing field? So please meet Leroy Schumacher. He is the grandfather of a Oklahoma burglar, and he decided to speak out after his 17-year-old grandson, Jacob Redfern, who had previously been in foster care, was one of 3 Oklahoma teens killed when they broke into a house and came face-to-face with the homeowner's son, who just happened to be armed with an AR-15 rifle. Well, Mr. Schumacher says that Leroy had been a pretty strong opinion about what went down that day, according to Leroy Schumacher, even though his grandson was in the middle of a burglary when he was killed. His death was unjustified, according to the grandfather. Now, the grandfather acknowledged that breaking into a house was stupid, but he thought that the AR-15 gave the homeowner's son an unfair advantage over the 3 burglars and that death wasn't the appropriate consequences for the team. Let's just stop right there. So you got 3 people breaking into a home, armed with a knife, masks on, in the middle of the day. So it's 3-1, and the homeowner's son says, oh, hold on a second. Let me defend my home. I'm in fear of death or serious bodily injury. And he opened fires on the burglars? I think that's the great equalizer, ladies and gentlemen. That is the theory behind firearms, is they are the great equalizer. Anyway, this story all begins when the 21-year-old Elizabeth Rodriguez, who police believe was the ringleader, a mother of 3 who's in need of some rent money, drove 19-year-old Maxwell Cook, 16-year-old Jake Woodruff, and 17-year-old Jacob Redfern, who she says were all living with her, to the Wagner County home. They first stole liquor, speakers, and a machete from the garage, but then they got a little greedy, right? The old pigs get fat, hogs get slaughtered, don't get greedy. So they break into the main house. The young men were all wearing black, donning masks and armed with brass knuckles and a knife. They go inside. Rodriguez waited with a teenager girl in the getaway car. Now, Zachary Peters, the homeowner's 23-year-old son, was taking a nap when he heard the door slam and glass shatter about 12:30 in the afternoon. Peters grabbed his father's rifle before coming face-to-face with the 3 suspects, who all froze when they saw him. Fearing for his life against the masked intruders and worried that they had a weapon, Peters opened fire. When asked if the suspect tried to hurt him, he admitted that he never gave them the chance. He shot the suspect closest to him first and didn't stop until the last suspect managed to run out of the house. That's when Peter said he retreated to his bedroom, locked himself inside, and called 911. And during the call, Peters pled for medical help for the suspects. But when they got there, it was too late. Now, when Wagner County Sheriff deputies arrived, Peters dropped his gun and followed their orders. All 3 suspects died at the scene, even though Rodriguez later admitted that one of the suspects made it to the getaway car, slid across the hood of the car, saying, "I got hit." Well, Miss Rodriguez later went to the police, admitted her involvement, and told the investigators that she had planned the whole thing. And she was arrested and charged with 1st and 2nd degree burglary, as well as 3 counts of 1st degree murder, since Oklahoma state law says that someone can be charged with a murder if another person takes the life of a human being during the commission of a felony. That's right. It's called the felony murder law. So if you plan a home invasion, a burglary, a dangerous classified felony under the felony murder statutes, and you go in, you're going to rob the liquor store, say, for example, or the homeowner, and they have a heart attack and die, you can be charged with felony murder. Or even one of the suspects dies because they get shot. All 3 of them dead. Felony murder. Ladies and gentlemen, you're engaging in dangerous conduct. Somebody dies during the commission of a serious felony. You can go to prison for the rest of your life. Anyway, so now Miss Rodriguez can face life in prison or even the death penalty. But it's the homeowner's son and the AR-15 that Mr. Schumacher, the grandfather, seemingly blames for his grandson's death. What these 3 boys did was stupid, the grandfather admitted. They knew they could be punished for it, but they did not deserve to die. Brass knuckles against an AR-15? Come on. Who was afraid of their life? Anyway, Zach Peters has not been charged with any crime because police say he acted in self-defense. The grandfather was not convinced that the shooting was justified, though, and he has reiterated his belief that the consequences did not fit the crime. Welcome to the Castle Doctrine. Stand your ground, whatever it is in your jurisdiction, ladies and gentlemen. Most states have it. Somebody comes into your house, they cross that plane of the door, right? That's what we've always said that. Once they cross the plane of the door, make sure you call the police and say you were in fear of death or serious bodily injury. You were scared. Make sure they cross the plane of the door, ladies and gentlemen, okay? You can't shoot them on the porch and drag them inside. It doesn't work that way. They got to cross the plane. Consult your local legal counsel in your own jurisdiction for specifics. Next, Alec Murdaugh. This man, you got to, he is tenacious. He does not give up. Obviously, that's why maybe he got away with his theft schemes for so long. Anyway, lawyers for Alex Murdaugh are taking two paths to appeal his murder conviction for killing his wife and son. First, saying that the court clerk pushed a guilty verdict to jurors to sell books and that the trial judge allowed improper evidence like the disgraced South Carolina's financial crimes. Now, the defense filed a 132-page appellate brief with the South Carolina Supreme Court. Now, prosecutors will obviously have time to respond, but they have to read the record from the 6-week trial that took place. And I hope there's a new trial. I hope there's a new trial, ladies and gentlemen, because I think he got screwed. Now, I think he totally did it, okay? And I believe that the jury got it correct, but the judge went over the top with all the financial crimes evidence. It could have been a couple of questions, but I think if I recall correctly, it was about 3 days of testimony of what an evil person I am because I stole all this money. It was over the top, 404B evidence, totally screwed. And I also think he should get a new trial because this clerk, the judge has found not to be credible. If she tainted it in one particular way, for future people to know that you can't engage in this type of conduct, you got to demand a new trial. And if they do, we'll be there to cover it. That's for sure. Anyway, the appeal details arguments that have already been made, even though objections during the trial or a hearing this year in which jurors were questioned about comments made by the former Colleton County clerk, Becky Hill, during the trial. Now, Murdaugh's lawyers wrote his murder convictions need to be overturned because the public needs more than just social media-fed ideas about the details of a crime that they did not witness. And they argued that providing Murdaugh with the fair trial that every citizen of South Carolina would expect for himself is necessary to ensure that no one, powerful or humble, innocent or guilty, hated or beloved, is proscribed from due process and the equal protection of the law. Hear, hear. Anyway, Murdaugh is serving a life sentence in prison for the shooting of his wife Maggie and their younger son Paul back in 2021. Can you believe it's already been 2021? Anyway, he adamantly denies that he killed his wife and son. Now, the defense did point out how little physical evidence connected Murdaugh to the crime. Investigators never found the rifle used to kill his wife and son, and a shotgun blast sent blood and tissue all around the small area and where the son was found dead. And only tiny amounts of blood were found on the clothes Murdaugh was wearing when he found the bodies, and no bloody clothes were found anywhere else on the property ever. Now, the defense said the state investigator shouldn't have been allowed to testify that markings on cartridges found at a shooting range on the family property matched those found at the killing because he never proved the markings are unique to one gun. Now, they said a blue raincoat with the tiny amount of gunshot residue shouldn't have been put into evidence because a witness testified about seeing Murdaugh with a blue tarp, not a raincoat. Anyway, the defense lawyers also said the judge should not have allowed evidence from the investigator who said he spent a weekend tossing an iPhone around his office to determine whether the screen, which comes on with a light touch, might not come on with a more violent motion. The expert witness kept no data and did not record his experiments. Now, prosecutors suggest that Murdaugh threw his wife's phone from his moving car as he drove away, but data from the SUV's computer showed the phone screen turned on 2 minutes before Murdaugh's vehicle passed the spot where the phone was found. Now, half of the appeal deals with the court clerk, and in January, a Judge Jean Toll ruled that while she couldn't believe Hill's testimony that she didn't talk to jurors about the case during the trial, she also couldn't overturn a verdict based upon the strength of some of the fleeting and foolish comments by the public-seeking court clerk because they didn't actively change the juror's mind, was the judge's conclusion. At least 3 jurors said Hill told them to watch Murdaugh's testimony in his own defense carefully, and one said the suggestion appeared to indicate he was guilty and couldn't be trusted. Now, the court clerk from a neighboring county testified that Hill told her she would write a book about the Murdaugh trial and that a guilty verdict would probably sell more copies. Now, the rest of the appeal dealt with the trial problems, including the decisions by the judge to allow 6 days of evidence about Murdaugh stealing from clients and his law firm after prosecutors successfully argued a possible motive for the killing was Murdaugh seeking sympathy to stop further investigations into missing money. The trial judge, Clifton Newman, said the jury was entitled to consider whether Murdaugh's apparent desperation and dire financial situation resulted in the killings of his family, and that he didn't think the financial crimes evidence alone would persuade the jury to convict Murdaugh of the murder. Now, the defense obviously objected at that time to all of that coming in, and in the court records filed this week, they cited cases in which appellate courts overturned murder convictions because evidence of infidelity or spousal abuse were allowed in trials, but prosecutors couldn't directly link them to the killing. The state was improperly permitted to introduce evidence into Murdaugh's alleged financial crimes solely to impugn his character, to bolster their otherwise weak case, his lawyers wrote in their briefs. And even if Murdaugh gets a new murder trial, he won't get out free because he's still serving that 40-year sentence for pleading guilty to stealing all that money, not to mention the federal case as well. Anyway, the Alec Murdaugh promised not to appeal the theft case, and we'll have to wait and see. Like I said, I think the damning evidence was the TikTok or some sort of reel that was there that had his voice. Not good for him. Lots of other troubles. But I think he should get a new trial because of the clerk's misconduct and all the 404B evidence. Some evidence would have been permissible, but 6 days, that's ridiculous. And remember, ladies and gentlemen, if the prosecutor's seeking to introduce 404B evidence, it means they got a weak case. It means they don't have anything else. They want to paint the person as a bad guy, enter into evidence what is strictly prohibited under the rules of evidence, because every defendant has a right to be tried on these charges and these charges alone. Not every other bad thing that he's done in his life to show that he's a bad person, and therefore he must have acted in conformity therewith in this particular case, therefore find him guilty. We'll leave it at that. We'll see what the appellate court decides there in South Carolina. Next, on this day in legal history, December 13th, 1913, the Federal Reserve System was established to serve as the central banking system of the United States, aiming to provide the country with a safe, flexible, and stable monetary and financial system. How's that working out? Next, December 13th, 1971, the United States Supreme Court heard legal arguments in New York Times versus United States concerning the publication of the Pentagon Papers, a pivotal case for freedom of the press and government transparency, ladies and gentlemen. That's right, the First Amendment, powerful thing. And then on December 13th, 1978, the first battered woman syndrome defense was used in a landmark legal argument, and the defendant successfully invoked the battered woman syndrome as a defense in a murder trial, influencing, obviously, cases throughout the world. Or throughout the United States, I should say, as most recently as Sarah Boone, for example. And next, on December 13th, 1980, John Lennon's killer, Mark David Chapman, was formally charged, sparking widespread media attention of the case of, obviously, the death of John Lennon. Some of the younger generation may not know who John Lennon is. He was a Beatle, ladies and gentlemen. And on this date in 1995, the United States federal court ruled, as it relates to cable companies, that they have to carry local television stations. Who knew? Who knew, ladies and gentlemen? You learn something new every day when you come to Crime Talk. And finally, our dumb criminal of the day. What can you do, ladies and gentlemen? You just don't get it. Anyway, this woman, incensed that relatives were praying to Jesus in her house, a Florida woman, told police that she prays using the Quran and doesn't believe in Jesus. Therefore, then she beat her brother, and, well, it got her arrested. So according to the arrest affidavit, the verbal praying dispute between Sherry Shagini and her brother, Peter Shagini, didn't work out well for everybody. So Peter told investigators he was praying with his wife using their cross when his sister got mad at him and told him to leave. Shagini According to the police, alleged first picked up Peter's phone and threw it on the ground, destroying it. And then she went to attack Peter, put his arms up to defend himself, but then Sherry bit his forearm. Shigini then threw Peter's stuff out of the residence and broke his cross. At one point, Peter told police that Shigini scratched her own neck and told him, "Now you're going to jail." Now, when the police arrived at their Vero Beach residence there in Florida, Peter had a bite mark on his right arm, which had visible bruising and was bleeding. His phone was shattered and inoperable. Peter told the deputies that he and his wife were at his home for a visit. His mother, who is there in hospice care, apparently. Now, during the police questioning, Miss Shigini claimed that she bit Peter in self-defense after he scratched her neck. However, a deputy reported examining Shigini's fingernails and found traces of skin under her nails consistent with her scratching her own neck. Anyway, Shigini was charged with 2 misdemeanor counts of battery and resisting arrest. The later counts resulted from her struggling with officers when they tried to handcuff her. She went to jail, released on her own recognizance, and is back in court in January for an arraignment. All right, ladies and gentlemen, that's all we have for you today. It was a long show. I hope you enjoyed it. You can enjoy it over the weekend. Thanks for watching. We'll see you next time. And remember, the Constitution matters.